Hi, my name is Whitney Lee. I'm the founding attorney of Wills for the People. This is a foundational webinar um, on demand recording for you to watch if you're wondering what even is estate planning. What is this language that we're using? Why do I need it? What does it entail? We're going to answer those questions for you here in this webinar. Who am I? Again, I'm the founding attorney of Wills for the People. I'm licensed in Georgia. I'm a court certified mediator, trained in transformative mediation and facilitative mediation. I am a race equity consultant. And then lastly, I am the host of Impostrix podcast. If you are wanting to work with me and you want to get a feel for who I am, definitely go check out Impostrix podcast. It's a show that validates professionals of color who navigate imposter syndrome and racial toxicity within their careers. All right. Now, let's get into it. Estate planning is for everyone. Let's just start here because often we grow up thinking that estate planning is only for wealthy people. Maybe the only people that we knew who had estate plans were white people. The only kind of language that we knew about estate planning is getting our affair in order or planning for the future or trust funds. Maybe we had heard about trust funds but didn't know what those were. So I'm going to dispel this myth right off the bat. Estate planning is for everyone. We're going to talk about some of the tools that you can use in estate planning and specifically what we do at Wills for the People. But let's just get it out of our heads right now. You do not need to be wealthy to have an estate plan. You also don't need to be nearing retirement age. We should be starting our estate plans as early as possible. So, what is an estate plan? It's a collection of documents that work together to dictate how your assets and your liabilities are going to be managed during your life and also how they should be distributed when you're gone. So, often people think that estate planning is just for your family once you passed away. Yes, that is a major component of estate planning. That is one of the major benefits of estate planning is that you get to decide who gets your home, who gets your car, who gets your wedding ring, who gets your baseball card collection. You do that in an estate plan. But also, estate planning involves planning for incapacity. When I say incapacity, what I mean is planning for if you become seriously ill and cannot make decisions for yourself. So, for example, if you are in a coma and you need somebody to make healthcare related decisions for you, or if you have Alzheimer's or some other cognitive disability and you're not able to make decisions for yourself, that's where certain aspects of your estate plan are going to come in. What are the foundational components of an estate plan? First, we've got your last will and testament. Many people are familiar with what a will is, but I'm just going to break it down for you here. Your last will and testament is the document that you create that says, this is what I want to happen to my property when I pass away. In order for your last will and testament to be valid, it must be an original document. It must have the original signature. So when you pass away and your family is looking to probate your estate, they have to have that original document. They cannot have a copy of that document here in Georgia. You can change your will while you are still living. So if you want to make changes to it, if you want to choose a different beneficiary, if you get more stuff in your estate, then you can add those things to your will. You will want to work with an attorney to do that. Do not write on your will after it has been executed, after it's been signed. Also, in your will, you can disinherit people. So, say you have an estranged spouse and you do not want that spouse to get your property, but you're still legally married. You would want to indicate in your will that you don't want this person to get your property. Okay? So a will becomes effective after death, meaning once you pass away, that is when your will is going to start actually dictating what happens. In your will, you decide who your executor is going to be. That's the person that is going to take care of the business of actually distributing your estate. Power of attorneys are a great tool, and these are tools for the incapacity planning. Power of attorneys are only active, they're only valid while you are living. Once you pass away, we're no longer dealing with the power of attorney. We're now in the land of the wills or the trust. I'll get to that later. Common language that we use to identify a power of attorney are durable power of attorney, advanced directive, and living will. Those two terms are used to refer to the what I call the healthcare power of attorney. So here in Georgia, we've got 3 power of attorney documents. We have the financial power of attorney, we have a healthcare power of attorney, and then we have a psychiatric power of attorney. Each of these documents allows you to choose somebody who is going to make those decisions on your behalf if you cannot. So for the financial power of attorney, that person can make financial related decisions for you. You're going to choose not only who the person is, but who the backup person is going to be, and then what specific decisions you want them to have authority to make. For the healthcare power of attorney, you're not only choosing who is going to make the decisions on your behalf if you can't, but you're also going to identify some specific decisions, like, do you want your organs donated after you pass away? Do you want your agent to be able to authorize an autopsy? Do you want to have life support, and to what extent would you want life support? Do you have religious beliefs that are going to preclude you, that are going to stop you from getting certain treatments like a blood transfusion? Okay, so the healthcare power of attorney gives you, or excuse me, gives your agent and your medical providers more information about what types of services you do or do not want. And then the psychiatric power of attorney is for people who have psychiatric disabilities, who maybe go back and forth between periods of doing really well and then periods of decompensation. This power of attorney document allows people to choose an agent, a person, to handle their affairs if they are in a period of decompensation. Trusts, there are many kinds of trusts. What we do at Wills for the People, and what I'm going to focus on here, is testamentary trusts and revocable living trusts. A testamentary trust goes in your will. It's just a part of your will. And once you pass away, that trust starts. Because it's in your will, it does need to be, like, your estate still needs to be probated. The revocable living trust, on the other hand, is a document that's separate from the will, but it does work together with your will. It is a document that you create while you're living. It is revocable, meaning you can cancel it, you can make changes to it. And in the trust, you, the settlor or the trustor, are putting in property. It can be assets, it can be a home, the title to a home, it can be shares of a business. You are putting those items into a trust so that you no longer own them, your trust owns them, or somebody else's trust owns them. The trustee is the person responsible for handling the business of the trust. So they're responsible for making sure that if there's a home in trust, that everything is getting taken care of with the home. If there's a business in trust, that everything is getting taken care of with the business. If there is a trust fund, if there's money, they're the ones that are actually going to be accessing the money and then sending it to the beneficiaries of that trust. And then the beneficiaries are the people that are receiving the benefit of the trust. Now, for revocable living trusts, you can be both or all 3 of those relationships. You can be the settlor, the person putting stuff in the trust, the trustee, the person deciding what's happening, or not deciding, but implementing the trust, and the beneficiary, the person that is receiving the benefit of the trust. So when you create a trust, you're creating a document that is dictating what happens to various items. You are transferring your ownership of various items into that trust, and then you're determining who is going to benefit from that trust and under what circumstances. The benefit to a trust is that you avoid probate. There are some caveats, and we would deal with that in our strategy discussion. if there are caveats that are going to apply to you, for most people, you will be able to avoid, or your family will be able to avoid, the probate process. Downsides of the trust is, frankly, that it's just more expensive. It's more expensive to set up a trust than it is to set up a will, and there's multiple steps. So trusts are really, really helpful. They're kind of the gold standard in estate planning, although not everyone is going to have an estate that needs a trust. Some of you don't need a trust. So we will talk about whether or not a trust is advisable for you right now in your life. This is also the type of thing where you don't get a trust now, but you can get a trust later. Okay? And then insurance and retirement. So estate planning is more than just these legal documents and handling probate, but it's also about planning for how is your family going to be supported when you pass away? And then when you retire from work, how are you going to continue to receive income? At Wills for the People, we do not handle insurance and retirement, but I wanted to include this on this slide because it's really important that as you are thinking about your estate plan, you are also thinking about, is your life insurance set up? What kind of life insurance do you have? Have you let your life insurance lapse? Do you want whole life? Do you want term life? If you're a business owner, do you have key person insurance? Do you have malpractice or general liability insurance? And then finally, what's really important for both insurance and retirement purposes is that you have kept your beneficiaries up to date in that system, because the insurance company will pay out to the beneficiary that money. That money is not going to have to go through probate first, for the most part. So what you need to do is make sure that your beneficiaries are of age. So they need to be over 18, or they need to, if you do want to leave it to minor children, you need to make sure that you have a custodian for that minor child. And that if you want money to go to a trust, you need to specify that the trust needs to be the beneficiary, not the person, a person. Okay. So one key component that I had left out about the last will and testament is that that is also where you're going to identify who you want to be a guardian of a minor child in case both of those child's parents pass away. One thing that's recently come up in Georgia is the transfer on death deed. This is now legal as of July 1st, 2024. This is an opportunity for homeowners to give their property to a specific person or people when they pass away. In order to do a transfer on death deed, you have to complete a deed document that needs to be witnessed and notarized and filed in the Superior Court of the county that your property is in. The person that you've selected to receive your property, once you pass away, then has to show up to the courthouse to file additional documentation in order to then claim your property as their own. So this is helpful for people who own one home and don't have other assets that they need to worry about, or maybe you want to make sure that your home goes to a specific person and you don't want it to be thought about. This might be a good option for you because transfer on death deeds do not require the probate process. Similar to a trust, a transfer on death deed allows you to pass property without going to probate court. So who needs an estate plan? Most people need an estate plan. People who have assets. So real property, financial assets, bank accounts. If you have personal property that is valuable, that you want to make sure goes to a specific person, you need an estate plan. Caregivers, parents and guardians, and pet parents. You need an estate plan to determine what is going to happen with your children, with the people that you are caring for, who is going to be their guardian, okay? Business owners need an estate plan because now you've got this asset and potential liabilities that you have to account for. People who are expecting to inherit real property or assets should have an estate plan, because if you don't have an estate plan, your heirs are going to be faced with this process of probate that likely will take some time and it will likely be a headache for them. And then lastly, people with blended families, separated spouses, and people who have children outside of being married. It's really important that you all have wills at least, and that in those documents, you are specifying the relationship of the child or the spouse. Okay, so for example, if you have stepchildren who you want to inherit from you, or step grandchildren who you want to inherit for you, it's important for you to indicate that they're stepchildren and to define, who you consider to be a child in order to inherit from your estate. Now, what happens if we don't get an estate plan? Georgia and other states have what are called intestacy laws that determine what happens when a person passes away, but they do not have an estate plan in place. Essentially, your family will need to go to probate court and file for your estate to be administrated. What will happen is the judge will appoint somebody to handle your affairs. That person will have to take inventory of what is in your estate and will need to determine what to do with your estate. If you have things that need to be distributed, they're going to be distributed according to Georgia's laws of intestacy. Those laws say who is entitled to your property and who is not. So, what this means is that if you don't create an estate plan, the state of Georgia will create one for you. It may leave out people who you would want to inherit. So, especially if you are somebody that has many children, if you are somebody who has an estranged spouse, if you are someone who does not have any heirs or children, and maybe you want to give property to a charity or to a friend, if you are somebody in a same sex relationship, but you are not married, but you want that partner to inherit from you or that partner's children to inherit from you. All of those are reasons why you need to have an estate plan because the laws of intestacy will likely skip that relationship that you have and will not provide those people with any of your assets. We hear a lot about celebrities who pass away without estate plans and how it took years and years, a decade even, for their estate to be settled. And of course, in those cases, people have millions of dollars. They've got, record label rights and all of these things. They've got properties, all of that. But this is not just something that wealthy and famous people have to worry about. I just did a talk with a group about a man named Evans Lee Jr., who lived in DeKalb County. He passed away without a will, and unfortunately, before his family could get to probating his estate, uh, they were victims of probate fraud, where someone else claimed to be his heir, petitioned the probate court to be able to be the administrator of the estate, and proceeded to steal everything of value and let his home go into foreclosure. What that meant was that during the year that the family, the true family, was fighting to have access to the estate was being diminished, things were being thrown away, mortgage and taxes were not being paid. The family ultimately did win their case against this fraudster. The judge gave the family the right to administer the estate and the right to the assets, but there was nothing left. There was literally not even the ashes of this man was left for the family to have. So that's what can happen, among other things. We're not even talking about just your family getting into fights about what should happen with your property. We're not talking about the expense of having to hire attorneys to go in and probate and represent your various family members. We're not even talking about the lost legacy, the personal property that might be lost. So much can happen if you do not have an estate plan. And so when we talk about getting our affairs in order, what we're really talking about is making sure that our family is situated, that our legacy continues, that the people who we care about get to benefit from our hard work and our labor over the course of our lifetimes. Because if we're not doing that, then what is it all for? Having an estate plan is a critical way for us to start growing generational wealth. Here in Atlanta, where I am, white families have 46 times the wealth as Black families. And while estate planning is not going to resolve this, it's not going to make wealth in Atlanta equitable, it is going to help make sure that what we have worked hard for, we are able to keep within our families so that the next generation of our family can benefit from those things, so that they can benefit from the equity in our home, so that they can benefit from the 20,000, 50,000, $1 million that I have in my bank account. Okay. So it's really, really important that we do this. Another thing that I'm going to have a separate video about is heir property. Making sure that we have an estate plan and specifically a plan for our homes is critical because our homes, for most of us, make up the largest asset within our estate. So that's the most valuable thing within our estate. We need to make sure that we are properly transferring title so that our family is able to actually receive the benefit of this property. All right. What are your next steps to getting started? You need an estate plan. Okay? Like point blank. You're watching this, you need an estate plan. At Wills for the People, we do provide estate plans and individual representation, but we also have a variety of services that are going to help you get started with this process. We are able to do what are called power parties, where I will come in, meet with your friend group, meet with your family. We will be social, eat food, and we will complete our power of attorney documents. I will walk you paragraph by paragraph through these documents so that all of your family and your friends are able to have these documents executed. And then when you're ready to take the next steps, you can. This is a great option for folks who have friend groups who have been talking for years about getting their affairs in order, but never have. This is the time to do that. We also offer educational sessions and family legacy planning sessions where we are coming into your family and talking about how your estate plans impact each other's estate plans and how the group of estate plans and how you're planning for your affairs is going to impact that next generation. So here's what I need you to do. Continue to do your research, and when you're ready, go to willsforthepeoplega.com and book an appointment. Book some time with me. You'll choose which service that you would like. We will meet for a new client call. From there, we will make sure that you got the package that you need. I will send you an invoice. I will send you your retainer agreement, and then we'll get started. If you're still not sure, or if you need to know more about how this works, feel free to check out our other videos, especially the video of how we work, because that's going to take you step by step through these next steps that are listed on the screen. All right, y'all have the information. I'm ready for it when I'm ready for you when you're ready for it. All right.